One of the recent issues that appears to be arising with co-ops and condominiums relates to the requests of a shareholder or a resident to harbor a dog in their apartment despite the house rules which typically exist in co-ops and many condominiums that prohibit a pet from being harbored in the apartment. Recently, our firm encountered a scenario where a co-op board which we represented contacted us and advised us that a shareholder was harboring a dog in their apartment in violation of the co-op's house rules. In the ordinary circumstance, we would then have a notice of default sent on to the tenant, shareholder, and request that the dog be removed in accordance with the co-op's proprietary lease and house rules. In this particular instance, we did just that. Unfortunately, the co-op board failed to advise our office that they had recently received a request from the shareholder requesting a reasonable accommodation based upon a medical necessity to harbor the dog in the apartment. In essence, the New York Executive Law and the Fair Housing Act provide that a co-op board must provide a reasonable accommodation to an individual who has a medical necessity. The law indicates that one of those accommodations would be to permit a person who is requesting to keep a dog in their premises based upon a medical necessity to be able to keep the dog despite the house rule. The clearest example of this is a blind person requesting to keep a seeing eye dog in their apartment. Now, most boards clearly understand that one, and I think that very few boards would ever deny such a request and would more likely than not grant that accommodation. The more difficult issue, such as the one that this co-op board was faced with, related to a shareholder who claimed that the dog was a quote-unquote emotional support pet, or commonly known as a comfort pet. These are pets where doctors have determined that it is a medical benefit or medical necessity for the individual to have the dog for some psychological or other reason. In this particular case, we served the default notice on the shareholder, and after the default notice was served, the shareholder contacted the co-op and said, "You can't ask me to have my dog removed. I have requested a reasonable accommodation under the law, and you as the co-op board must grant me that accommodation." This particular co-op board disbelieved the basis upon which the request was made and ultimately indicated that they would not grant the request. What this ultimately resulted in was the shareholder filing a complaint with the New York State Division of Human Rights against the co-op. The co-op was then relegated to dealing with that complaint, which includes putting in a response to the New York State Division of Human Rights. The New York State Division of Human Rights, after reviewing the documentation that was provided by the shareholder who requested the accommodation and the co-op, indicated that they believed there was what's called probable cause. What does that mean in essence? That means that the New York State Division of Human Rights believed that it was likely, based upon what they were presented, that the co-op board discriminated against the individual by not granting the reasonable accommodation. As a result, when this occurs, the co-op is left with several options, one of which is to go for a hearing before the New York State Division of Human Rights, or the other alternative, which we frequently recommend, is that the co-op has the right to demand that the individual bring a lawsuit in a civil court. We did just that. The lawsuit was actually commenced. After the commencement of the lawsuit, we requested what is commonly known as an independent medical examination. Basically, this is where the shareholder must submit to a medical examination by a doctor of the co-op's choice to determine whether or not there in fact exists the medical necessity for the dog to be maintained in the apartment and for the accommodation which was requested. In this case, the doctor actually confirmed that there was a medical necessity, there was a nexus between the request and the need for the dog, and as such indicated that the accommodation should be made. Accordingly, this particular case actually settled, and the shareholder was ultimately given the accommodation. Now, a couple lessons that should be learned from this. First things first, had the case not settled and the board granted the accommodation, there are a number of damages and liabilities that the co-op board its managing agent, and anyone else that was involved could be liable for. One of them, which is usually a significant one, is that not only are you responsible for paying for your own lawyer's fees, but you're also responsible for paying for the legal fees of the shareholder who had to bring a complaint to get an accommodation which they were legally entitled to. You could also be held liable for other damages as a result of not granting the accommodation. What do we learn from this? We learn that when you receive a request for a reasonable accommodation, and again, whether that request is for an emotional support pet or whether that request is for moving someone's parking space closer to their apartment, that you deal with it very seriously. What should be the first thing that you should do? The first thing you should do is you should contact the board's attorney and allow the board's attorney to give the board and the managing agent guidance on how to deal with it. Again, the law, as it is presently written, is written in a very favorable manner to the person who is making the request. What do I mean by that? The law actually says that if the person's disability is visible to you, you actually cannot do anything further. And what do I mean by that? You can't ask for any additional information from that shareholder. Again, the blind person asking for a seeing eye dog, you know the blind person is blind. You can't ask them to get you a doctor's letter to confirm that they're blind. And there are many other instances, someone that may be walking with a cane who needs certain assistance, again, visible. If it's not visible, the next thing the law says that if the person provides you with a medical doctor's letter, which says that the person has the need, you also can't do more than that. Granted, you do need the letter from the appropriate medical profession. You certainly would say that a letter from the person's podiatrist would not be enough for the person asking for the comfort pet, but a letter from a psychiatrist or a psychologist probably will be sufficient. And again, you have to be careful, because if you go too far, that's when you start to expose yourself for the liability that we've discussed. So it is very important that when you are faced with one of these requests that you recognize that there are certain legal benefits that people with disabilities are entitled to, and that you deal with them in just that manner, so as to limit yourself from liability. And that means that in many instances, I know that in speaking to many of the co-op boards that we represent, when they're faced with these requests, that the co-op boards say, you know, I don't understand this. Why does the person need a pet for emotional support? This is just an afterthought based upon us serving a default notice. That's also an interesting one, because the fact that the person may have not disclosed to you and their co-op purchase application that they needed the pet is not enough to deny the request. So if the person shows that they are justified in the medical need, just because they lied on an application is not generally going to be enough of a defense for you to deny the request. So again, if you are faced with one of these reasonable accommodation requests, provide it to your co-op's counsel immediately and address it as quickly as possible, as the law also says that the requests are supposed to be dealt with in an expeditious manner.